afternoon. Thank you all for attending today's roundtable on the implementation of the Trademark Modernization Act, or TMA. This roundtable is being recorded and will be made available for viewing on the USPTO website within 2 to 3 weeks. If you have general questions during the roundtable or would like to request to provide comments today, please send an email to tm_webinar@uspto.gov. If you would like to submit written comments, please email them to tmfeedback@uspto.gov. Now, I will turn it over to Commissioner for Trademarks, David Gooder, to provide opening remarks. Commissioner Gooder.
Thanks, Tasha. Good afternoon and welcome, everyone. Thank you for joining us in this virtual roundtable regarding the implementation of the Trademark Modernization Act, really the first significant change in trademark law in probably 15 years. 1 year ago tomorrow, I was sworn in as Commissioner for Trademarks. And although I've been a trademark lawyer for my entire career as a lawyer, in this past year, I've seen the trademark ecosystem from many new and different perspectives. One of those is the damage being done to our trademark register and the need to better protect it for not only trademark owners, but trademark practitioners as well. I know we're all in agreement that the register must be accurate in order to be really useful to established companies as well as startups and entrepreneurs. The critical business and branding decisions that they make rely on that. Unfortunately, our register is being plagued by bogus claims of use and deadwood registrations. Over the past few years, we've been busy with multiple initiatives to address these concerns and to increase the accuracy of the register. Like most countries, we started requiring foreign applicants to have U.S. counsel when filing submissions. We increased scrutiny of the proof of use required to support registration in both examination and post-registration processes. And more than 2 years ago, we launched a special task force that not only investigates suspicious behavior and troublesome trends, but goes after those attempting to cause it. And we're pursuing login requirements that will increase our database security in the future and allow us to better trace bad actors in our system. While these are all strong weapons in our arsenal, we will soon have a new tool, and it's called the Trademark Modernization Act. For the USPTO, the TMA does the following things. First, it codifies the letter of protest procedure designed to allow third parties to submit evidence during the examination of an application, evidence such as claims of use in an application that the petitioner believes are inaccurate. Secondly, the legislation gives the USPTO the authority to shorten the response deadlines so that suspicious applications can be handled and disposed of more quickly. Third, the legislation provides new non-use cancellation mechanisms, expungement and re-examination, that allow registrations that are not in use as required to be challenged either by third parties or by the director on their own initiative. The good news is that the TMA provides a number of useful tools to protect and improve the integrity of the trademark register. The challenging news is that we only have 1 year to get it implemented, and we want to accomplish that in a way that best serves the entire trademark community. And it's with that in mind that we are delighted to have this opportunity today to get your feedback on the TMA. Later this spring, we will publish a notice of proposed rulemaking to implement the provisions of the Act. And as we embark on this path, we want to ensure that we consider all of your input, which is why we're here today. Please know that your input and feedback will be carefully considered. And before we move ahead today, I'd just like to thank all of you, the participants that have taken time to join us today, and especially those who have prepared comments for today's event. I'd like to thank our speakers from the office, Amy Cotton, Acting Deputy Commissioner for Trademark Examination Policy, and Jerry Rogers, Chief Administrative Judge at the TTAB, and everyone who worked behind the scenes to make this roundtable happen. And to all of you, thank you for taking time out of your busy schedule to join us today. Your contributions will go a long way to helping make the TMA the best it can be and to ensure that the U.S. Trademark Register remains at the forefront of promoting IP accuracy and integrity throughout the world. Thank you. And now I will turn it over to Amy, I believe.
Thank you, Dave. I need the slides given over to me. There we go. Thank you so much, everyone, for coming today. Wanted to share that the office's appreciation for all the input that you all have given us and will continue to give us as we develop this rule package. Dave did set the stage a bit for us, but I wanted to go into that a little bit more, the broader context of why the register protection initiatives that the USPTO is pursuing. In recent years, the PTO has received an increasing number of trademark filings with questionable and sometimes bogus claims of use. Use matters because the U.S. Trademark Act requires that trademarks be used on goods or in connection with services as a condition for obtaining and maintaining the U.S. registration. Furthermore, this use requirement ensures that the Federal Trademark Register reflects actual marketplace use of the trademarks that allows entrepreneurs, innovators, and brand owners to make better marketing and branding decisions. Bogus use claims devalue the usefulness of the register for businesses. Registrations that are not accurate are invalid, and they're subject to challenge by third parties. But until they are challenged, these invalid registrations take up space on the trademark register, creating clearance problems for you and increasing the cost of doing business. Registrations procured through false claims of use or other improper behaviors call into question not just the accuracy of the U.S. Trademark Register, but the integrity of the register and those registrations the USPTO issues. If the USPTO issues registrations that lack integrity, the value of those registrations diminishes. Likewise, the USPTO loses the trust of our customers when they receive scams and solicitations that trick them into paying for services they don't need or never get. So we have been working on register protection initiatives for quite some time. Our goal is to improve the accuracy of the submissions that we receive. Accurate submissions allow us to increase examination efficiency and get you your registrations faster. Accurate submissions allow us to issue accurate registrations that hold up better against challenges in court. Sometimes, inaccurate submissions are generated through mistake or misunderstanding of U.S. laws or rules. Other times, inaccurate submissions are due to bad intent or bad behavior. So to improve the accuracy of the submissions, we have to deter bad behavior. And here are some of the tools we have employed to achieve those goals, as noted by Dave. First, the Special Task Force is that group that's responsible for investigating improper behaviors and scams and evaluating whether sanctions are necessary to address them. Login now is mandatory for anyone filing an electronic form. That allows us to better track filing behaviors. There are two more forthcoming phases, identity proofing and role-based access, which will further increase database security. On scams, we have limited legal authority to take action against scams and solicitations, so we're really focused on education and outreach to alert our customers of scams and to share information with law enforcement agencies investigating bad actors. As for the post-registration audit program, that's been in place since 2012. It clearly shows that registrants are consistently filing inaccurate use claims in their maintenance filings. To address this, the USPTO is now charging $250 per class deletion fee every time a registrant files a maintenance filing that, upon examination or audit, is found to be deficient as to use claims. You all know about the U.S. Counsel rule. We followed the practice of most other countries, and last year we started requiring foreign domiciliaries to be represented by a U.S. licensed attorney. This rule is designed to improve the quality of submissions by requiring the use of attorneys who are bound by ethical rules to follow USPTO rules of practice and their own state bar codes of conduct. As Dave noted, we've increased specimen scrutiny, specimens of use, and we've issued guidance designed to give our examining attorneys more power to issue specimen refusals when the specimens on their face raise questions about their legitimacy. We are also working to refine and implement IT tools to assist with identifying doctored or fake specimens. Now, lastly, as Dave noted, the TMA provides us additional tools to advance our strategy of increasing accuracy of our trademark register. About 2 years ago, when we were facing a surge of applications with sketchy specimens, Congress asked us how they could help us to respond. We asked for these tools that are in the TMA. First, we asked if the letter of protest procedure could be codified so that we could have clear authority to charge a fee and to cover the cost of the procedure. Next, we asked for authority to shorten the 6-month response period so we could move suspicious applications through the system faster. Lastly, we asked for non-use cancellation procedures that were faster and cheaper than trademark trial and appeal board proceedings that were not a default judgment. So first, with letters of protest, this procedure, of course, has been in place for years, and all the TMA does is codify that practice with a few minor tweaks. Typically, third parties cannot intervene in someone else's trademark application without filing an opposition at the TTAB. The letter of protest procedure allows third parties to send evidence to the USPTO regarding another's application. We review that evidence and determine whether the evidence is relevant to a ground of refusal, and if so, we forward that evidence to the examining attorney. This is a way for third parties to bring something to our attention that we might otherwise have missed or we don't have access to. The tweaks that I spoke of to the existing letter of protest procedures are: the legislation authorizes us to charge a fee, which is now $50. Second, Congress imposed a 2-month time limit for us to send the relevant evidence to the examining attorney. Everything else remains exactly as it has been for years, as outlined in the Trademark Manual of Examining Procedure. Next, we have the flexible response period. Typically, as you know, applicants have 6 months to respond to an office action. Our data suggests that some applicants take advantage of the full 6 months before responding, but many others move quickly to respond to the office action. The full 6-month time period may be reasonable and even necessary for a complex office action. However, for responses to office actions with fewer refusals or simple requirements like U.S. counsel, 6 months is too long. That lag time means that applications are taking up space in our system longer than they really need to. The TMA authority would allow us to shorten response times to increase examination efficiency and decrease pendency. How short should the time periods be, and when shorter periods would be offered are topics to be determined in our rulemaking process, and we welcome your input on this question. The TMA includes 2 new mechanisms for getting deadwood off of the register. The key things to remember about these new proceedings are that, number 1, they're not abandonment proceedings, so intent to resume use or commence use is not relevant. 2, they are non-use cancellation proceedings where use was required as of a certain date and there's evidence that the mark was not in use as of that date. Number 3, these proceedings are before the director without having to file a petition to cancel at the board. The goal, of course, is to create processes that are potentially quicker and cheaper than a board proceeding that's not likely to result in a default judgment, that is. There are 2 targets of these proceedings. Number 1, those marks that were never used, and 2, those were not used as of the relevant date. Further, you should know the expungement claim will also be available at the TTAB as a new Section 14 ground for cancellation of registrations where the mark was never used in commerce. This claim does not supplant or replace existing non-use claims at the board. An expungement claim can be combined with other claims, including non-use or abandonment claims, in petitions to cancel at the board. To start the proceeding before the director, a third party or the director must submit a request to institute an expungement or reexamination proceeding. The request can cover some or all of the goods or services in a registration, and those rules, the rules that we're working on will need to address in more depth what would be required in such a request, but here are the basics as laid out in the statute. Under the statute, any person can request proceedings be instituted. This means that there's no standing requirement. The director may also request proceedings to be instituted against a registration. Expungement proceedings can be requested as to use-based registrations, as well as those registrations issued under Section 44 or 66. Reexamination proceedings can be requested as to use-based registrations where use was required either at filing or at the SOU-AAU stage. If a registrant submitted specimens to us that were accepted, but based on other evidence should not have been, a third party or the director can request reexamination of that claim of use. Under the statute, excusable non-use is only available as to a Section 44 or 66 registration in an expungement proceeding. Excusable non-use is not available as a defense in a Section 1 expungement proceeding or reexamination proceeding. This is because the USPTO would not have accepted a claim of excusable non-use as of the date of application in a Section 1A application or the date of the statement of use or amendment to alleged use in a Section 1B application. An expungement or reexamination proceeding is looking back as to whether that use claim during the application examination process was accurate. If excusable non-use would not have been accepted then, it cannot be relied upon by the registrant now to defeat against a claim of non-use as there was relevant dates in an expungement or reexamination proceeding. The request for institution of these proceedings can only happen during certain windows of time. This is a quiet title provision and designed to prevent abuse. For expungement, that window is year 3 to year 10. Post-registration, for reexam, that window is from year 0 to year 5 post-registration. However, the TMA provides that for the first 3 years after enactment, any registration, regardless of how old it is, may be subject to request of institution for an expungement proceeding. Where the registrant cannot establish use of the challenged goods or services, those goods or services will be canceled from the registration in whole or in part. The registrant may appeal any resulting cancellation from the director to the TTAB and then to the Court of Appeals for the Federal Circuit. As for abuse provisions, the statute provides that once a good or service is attacked and survives because use was established, those goods or services can never be attacked again. We are drafting rules to design these proceedings right now. While we're looking for feedback on any aspect of TMA implementation, we are especially interested to hear from you on the issues listed here. What should constitute a reasonable investigation? What are the general types of evidence that could support a prima facie case? What should the set response and extension time periods be? What limits should be set on the number of petitions for a particular registration? How should an expungement and reexamination proceedings, how should they relate to other proceedings concerning that same trademark registration? As Dave noted, we have 1 year to implement these proceedings. We're working on a draft rule package and we'll be sending it through clearance within the administration in the coming months. We will issue the Notice of Proposed Rulemaking, the NPRM, in the spring on the federalregister.gov site. Once the NPRM issues, we will hold a public roundtable to collect feedback on the actual text of the proposed rules. All public comments should be submitted in writing to the federalregister.gov site at that time. Of course, once we receive those comments, we will assimilate and respond to those comments in the final rule. That final rule will publish in December. We are required to implement the expungement and reexamination proceedings by December 27, 2021. The letter of protest procedures are also required to be implemented by that date, but of course, those are actually already implemented in practice for many years and by rule as of this past January 2, 2021 in the Trademark Fee Adjustment Rule. The implementation of the flexible response period does not have a deadline for implementation. Nonetheless, in light of the surge of applications we're currently experiencing, we are interested in pursuing the flexibility inherent in the TMA statute so that we can address efficiencies in examination. As for USPTO resources, we have a TMA webpage that includes links to the legislation and an email box for your feedback on TMA implementation. We want to hear from you through that email box. Once we receive input, we are putting all stakeholder input on our webpage so you can review the suggestions that have already been made. And we're using that feedback to shape the rule package as we draft it right now. Once the Notice of Proposed Rulemaking issues, we will do this whole consultation process again to see what you think of what we drafted based on your input this time around. As for today, we're delighted to have so many speakers share their views. We want to move forward to that right now. Keep in mind, each speaker will have 5 minutes, and when there's 1 minute left, a notice will appear on the screen. Please wrap up so that we can next move to the next speaker. And with that, I'd like to move to the first speaker to give remarks today, which is Ted Davis, I believe. Mr. Davis, you should be being elevated to a panelist.
Itself. Hi, this is Ted Davis with Kilpatrick Townsend. I appreciate the opportunity to comment today. I have two personal concerns regarding the rulemaking. The first of which is that the statute itself neither defines the responsive obligation of a registrant targeted by one of the new proceedings, nor directs the office to engage in rulemaking on the issue. This issue has been raised by some of the intellectual property constituencies, and I therefore won't belabor it here, except to note that it has arisen with increasing frequency in my discussions about the TMA with our firm's clients. And just to give you two examples that have arisen, the first is whether a sworn verification of a responsive showing is necessary. Another is whether everything the registrant submitted as part of, say, a secondary meeting showing will automatically be a matter of record, as would be the case in an ex parte proceeding, or alternatively, is all that matters what the registrant submits in the course of the proceeding. The nature of the registrant's responsive showing is significant enough of an issue that registrants should not have to wait until the case law gives them definite answers, perhaps years from now, and I therefore hope the rules will preemptively address it. The second issue cuts in the opposite direction, and it relates to the potential consequences of a registrant failing to carry its burden in one of the two ex parte proceedings. The statute contemplates that the director will cherry pick a problem good or service out of the registration in question. But if that's the sole consequence, the office's experience may well be similar to what happened under the original iteration of the post-registration audit program, which is that registrants who know they don't have use will simply ignore the proceedings. And if, as many of us have heard from the House subcommittee staffers, that the goal is to change registrants' behavior on the front end, it seems that something more should be required of a registrant in these circumstances. Perhaps, for example, a fee to keep the remainder of the registration up and running. Again, thank you for the opportunity to comment.
Thank you very much. I appreciate your comments. Next, we have Allison Ricketts, and I believe she has slides that we will be projecting as well.
I'm Allison Strickland Ricketts. I'm a partner with Frost Zelnick, and I appreciate the opportunity to comment on the planned implementation of the TMA. Next slide, please. My questions relate largely to how the new proceedings will be integrated with existing proceedings. So for example, once actually there was a slide before this one, or there should be. This should be slide number 3. There we go. So once a proceeding is commenced, will registrants be able to file a Section 7 request to amend their registration, such as to delete goods at issue in the proceeding? And if so, will the fee for Section 7 that is only deleting classes, goods, and services be waived, as was the new rule announced in the recent fee setting that went into effect on January 2, 2021. Next slide, please. Similar question about filing a voluntary surrender. Once a proceeding is commenced, will a registrant be able to file a voluntary surrender of the registration or portion of the registration, such as to delete goods at issue in the proceeding? In my view, this should be permitted, since the animating purpose of the new provisions is to remove deadwood from the register. I think that perhaps even the notice notifying a registrant of implementation of the proceeding might inform them of these avenues that are available to go ahead and respond to the notice by deleting the goods that are not in use. I would just observe too that right now there is no obligation on Section 44 and 66 registrants to delete anything until the time comes to file the Section 8 or 71 between the 5th and 6th year anniversary. But it may well be that some of them would be willing to do so at an earlier time if such a proceeding is commenced. So I think that they should be given that opportunity to do so at perhaps less expense, well, certainly less expense to them and less expense to the office for evaluating, all the evidence of use or non-use that might be provided. And in the event that registrants opt to take advantage of filing a Section 7 or a voluntary surrender and resolving the proceeding in that manner, might the petitioner receive a refund of part of its fee, since the office won't have to do the second half of the work. Next slide, please. The next question relates to timing when a Section 8 or 71 declaration comes due during the pendency of an expungement proceeding, because those can be between years 3 and 10. I assume that the registrant will be still allowed to file its Section 8 or 71, which is required in order to maintain its registration. But perhaps it would be good if the rules made clear that, the registrant is still afforded an opportunity to make those filings. And I would assume too that they will be allowed to delete goods if they are filing a Section 8 or 71, just as they would in the ordinary course, even if there is a proceeding, an expungement proceeding that's open against them. And then if all the goods and services at issue in the proceeding are deleted as a result of a Section 8 or 71 filing, what will be the disposition of the expungement proceeding? Next slide, please. Likewise, if a registration is involved in an inter partes proceeding at the board or federal court litigation that could result in cancellation of the registration in whole or in part, can expungement and re-exam proceedings be instituted nonetheless? Does it depend on what the basis for the cancellation is, i.e. likelihood of confusion might be different than if the proceeding actually directly addresses allegations of lack of use? Or will proceedings in that event perhaps be suspended, like TTAB cases sometimes are suspended awaiting the outcome of a federal court litigation? Next slide, please. With regard to the flexible response periods, I actually would urge you to delay implementation of rules to alter changes to existing response period. There's a lot of work to be done to meet the statutory requirement to implement the expungement and re-exam by December 27. And this is true on the policy side and the rulemaking side, as well as on the back end of creating systems to provide this new functionality. And I just heard you announce that you're also still planning to try to introduce some of the other security features with logins and role-based access to the system. That sounds like a lot going on to me to try to implement. And I think that since you aren't obligated to change the response periods, I think it would just produce a lot of extra work at a time when you need to be focused on the things that have to be done in time. I guess if you want to make shorter response periods for simply in cases where non-US domiciled entities haven't appointed an attorney, that might be one discrete case where it would be warranted and worthwhile. But as a larger issue, I would urge you to delay that. Thank you very much.
Thank you, Allison. I appreciate your comments. Next, we have Michael Chiappetta. Mr. Chiappetta?
Yes, can you hear me?
Yes, we can.
Okay, great. Yes, my name is Mike Chiappetta. I'm from Practical Law. My question concerns the new cancellation claim based on non-use. Section 14 has been amended to allow a cancellation claim based on complete non-use, and that claim may not be asserted until 3 years after the registration issues. The statutory language also says that nothing in this provision shall be construed to limit the timing applicable to any other grounds for cancellation. The new claim, I think, can fairly be characterized as a non-use claim and seems to establish this firm 3-year period during which one can't assert it. But the traditional void ab initio non-use claim could be asserted at any time within 5 years after registration. The question is whether the traditional void ab initio non-use claim qualifies as an other ground for cancellation such that it is unaffected. So can I assert the traditional void ab initio non-use claim during the first 3 years of registration? Now, I just note that Amy indicated in her opening remarks that this claim will not replace existing non-use claims. But I suppose my concern is that if this is not clarified in the regulations, a defendant inevitably will argue that a void ab initio claim is subject to the 3-year limitation. And I just want to avoid the situation where the TTAB has to interpret the statutory intent. And so I just thought this is something that should be flagged and perhaps clarified in the regulations when they are issued. I just also note that if the void ab initio claim still stands, assuming it does, it seems to render the 3-year limitation in the statutory language fairly meaningless. I mean, I can't challenge a 1-year-old registration on the ground that it's never been used, but I can assert a claim that it wasn't in use as of the application filing date or as of the date of an allegation of use was filed if it's an intent to use application. This just seems counterintuitive to me. But that's all I have to say.
Thank you so much, Mike. Appreciate that.
Yep.
Next speaker, we have Eric Perot. Mr. Perot, you're on.
Hear me?
I can hear you.
Excellent. Yeah, and I really appreciate the USPTO providing this forum to discuss the thoughts on the TMA. I partner with Gerben Perot in Washington, D.C., and I do think that there's been no bigger threat to the integrity of the U.S. Trademark Registry than this influx of fraudulent applications. And we've seen it for the past at least 4 years, and the problem continues to grow. For a little bit of context, the kind of applications that the expungement and reexamination proceeding would be particularly helpful against are some of these like 150 applications filed by a single attorney that contains the goods false beards, and another, the same attorney who filed a baffling combination of cages for household pets, cruet sets for oil and vinegar, and ski wax brushes. And so I think that these the new proceedings would be particularly helpful in going after those types of applications that seem highly unlikely to ever have actual use together. And the questions that I have in particular are how this would be most useful to trademark owners. And the first is that I understand that this procedure, that expungement and reexamination is would be faster and cheaper than a contested dispute at the TTAB. But with the parties that are involved, I believe that this would be most useful if it was faster and cheaper than at least as fast or at least as cheap as a default judgment before the USPTO, as most of the parties that would be subject to these would not be in a position to respond with use, given that the wide-ranging applications that they applied for. And if there is a way to make it that it is as fast as a default judgment, I think that that would be preferable. Right now, a petition to cancel a single class application is $600 with a $200 refunded fee where the claim is based on non-use or abandonment and receives a default judgment. And we can get that done in about 90 to 120 days. That keeps increasing, but ultimately, that is kind of what we're working with right now to make a very similar non-use claim before the board. If expungement and reexamination is more expensive or it takes more time, then I believe many of the clients that I represent will likely just go the route of the TTAB, given the types of applications that they are and the high likelihood that they will receive a default judgment in response to the claims that they're being made. Which would further put burden on the TTAB that is already experiencing a strain of increased filings and pendency times. For flexible deadlines, I think that the biggest key is predictability, because with docketing systems and other things to try to determine what a due date is for any particular proceeding should be across the board. It should not be up to each examining attorney to have the discretion to set shorter deadlines, and it should not be on a case-by-case basis. For letters of protest, we are thrilled that Congress has codified this. We think it's an underused system that gives trademark owners the chance to head off an expensive, time-consuming inter-parties proceeding and provide the examining attorney with additional context and information that they may not have been able to have access to in the short period of time that they examine this. However, my concern is the new mandate of a 60-day period. With the current staffing of the petitions office, I believe that will be difficult to reach because of just the influx of new petitions causing a delay, and ultimately making sure that the staff members, whether they're attorneys or administrative staff, have the training and manpower necessary to meet these new requirements under the TMA. something we really think would be important to the success of this program.
Thank you very much, Mr. Perot. Appreciate your comments. The next speaker we have is Daniel Kelly. Mr. Kelly?
Yes, can you hear me?
Yes, I can hear you.
Great, thank you. Good morning and good afternoon. My name is Dan Kelly. I am Deputy General Counsel at Vista Outdoor, and Vista Outdoor is a house of brands. We own such brands as Camelback, water bottles, Bell helmets, and Bushnell optics. I just wanted to flag really one issue regarding reexamination and expungement. I certainly acknowledge the deadwood problem, and I'm glad to see that we're taking steps to address that. My concern is that in fixing that issue, we don't create other problems. And in particular, I'll draw an analogy to the rise of online commercial marketplaces and platforms. When those systems were built, I think few people envisioned the breadth of problems that would engender regarding counterfeit products. And of course, many parties have taken steps to address those, including the platforms themselves have created robust systems that are designed to empower companies to report counterfeits and have them taken down. Unfortunately, this has led to an even further problem, which is that in certain places, those systems themselves are then abused, quite often by competitors filing what are called false flag takedowns and whatnot. So this is really just to sort of take a lesson from that. We could also think analogously to a little over a decade ago when patent marking statutes were abused by opportunists. So I just wanted to encourage those who are involved in the rulemaking process to, consider carefully all of the potentials for abuses that can arise, and think through and plan for potential bad actors or abuses at the outset. Only I have 3 ideas concretely to suggest in this regard, and this is probably by no means a complete list or perhaps even the best ideas, but one is making filing fees significant enough to ward off nuisance filings. Secondly, consider perjury recourse for bad faith filings. And then third, irrespective of those other 2 suggestions, consider implementing something along the lines of a 3 strikes rule against frivolous filings. And those are my comments. Thank you.
Thank you very much, Mr. Kelly. Next, we have Michael Kelly.
Hello? Can you hear me?
Michael?
Yes.
We can hear you.
Great. Thank you and good afternoon. I'd like to thank Commissioner Gooder, Deputy Commissioner Cotton, and Chief Judge Rogers for the opportunity to provide input regarding the implementation of the Trademark Modernization Act. My name is Michael Kelly, and I am a Senior Corporate Counsel of Intellectual Property at Amazon. Amazon appreciates the dedication and hard work that the office has put into this process by soliciting these comments and receiving stakeholder feedback. We applaud the office's active engagement with all these stakeholders to maintain the integrity of the U.S. Trademark Register, remove improper trademark registrations, stop bad actors from obtaining rights that they shouldn't, and close gaps to reduce vectors of abuse. Amazon is a large customer and steadfast supporter of the Trademark Office. Trademarks are vital to Amazon's global business, both to our own business and, just as importantly, to the numerous selling partners who build and grow their businesses on Amazon. Brands are vital to commercial identity and establishing customer trust. To safeguard the integrity of the Trademark Office, the implementation of the Trademark Modernization Act should avoid unintended consequences that might open up new abuse vectors to bad actors or complicate the trademark application process to a degree that limits the access of small businesses and those who choose to file their own trademark applications. To that end, our comments today concern potential abuse of the newly established ex parte procedures in the Trademark Modernization Act and ensuring clarity and consistency in response times during prosecution of trademark applications. There must be sufficient gatekeeping mechanisms to avoid potential abuse of the new ex parte procedures to discourage bad actors who would undermine the goals of the Trademark Modernization Act. There are several potential gatekeeping mechanisms that we propose as options for consideration, including 1, establishing an appropriate bar for reasonable investigations and the evidence that would support an ex parte proceeding. 2, filing fees at least comparable to those for opposition and cancellation proceedings. And 3, low cost and low friction means of dismissing ex parte proceedings when it can be quickly established that a proceeding lacks merit. With respect to flexible response periods, Amazon believes that clarity and consistency of response periods will be best to serve the goals of the Trademark Modernization Act. While there may be a place for examining attorney discretion, response periods of less than 6 months should be used sparingly. Reserving shorter response periods for refusals that are linked to abuse vectors observed by the office or non-substantive refusals helps avoid a potentially disproportionate negative impact on small businesses and less sophisticated filers who are possibly more susceptible to procedural default when faced with flexible response times. Amazon appreciates the opportunity to provide input on the Trademark Modernization Act implementation process and is standing by to help support the Trademark Office on implementing the bill as the process goes forward. Thank you for allowing Amazon to provide these comments.
Thank you so much, Mike. Appreciate your comments. Next, we have Jian Xiao. Okay, I understand that Jian Xiao is not online, so we will move to our next speaker, Thomas Brook. Thomas Brook, are you online? Okay, I think we'll be moving on. We have, let's see, Zenga Wasimi. You are next. I see you're on camera, but we don't have audio for you yet. Looks like we are connected audio, but you're on mute, Zenga.
How about now? I think you just unmuted me.
I think you, yes, I hear you now.
Okay, great. Good afternoon. I'm Nzinga Wasemi, and senior attorney and director for the Artworks Legal Incubator and Residency Program. I personally was extremely excited to hear the new procedure set forth and the announcement and the Trademark Modernization Act. I said monetization. I'm always talking about how can we monetize intellectual property. But as a practitioner and more importantly, an educator that trains new and transitioning attorneys, I'm thankful for this opportunity to comment and share a bit of what we experience at Artworks, working with artists as well as emerging businesses. The rules that we believe will be most effective and efficient in the process of applications are the expungement procedure and cancellation based on non-use, flexible response periods for office actions, third-party submissions, as well as the rebuttal presumption. So with the expungement, many times while conducting trademark searches on behalf of our clients, we find goods or services or goods and services in a registration listed as active, even though the registrant has never used that trademark in commerce. This procedure will be extremely effective, we believe, in helping businesses obtain trademark protection in instances where they may have been blocked, due to these type of registrations where the goods or services simply are not in use. This rule brings, I believe, a little bit of fairness to the process, and to balance the process for those that are concerned about this expungement, there is the examination proceeding, so I'm glad that that's there. Next, the flexible response periods for office actions. Now, contrary to some comments, we believe this rule will be extremely helpful because oftentimes the applicant does not need the entire 6 months to respond. And when they do respond, many times it results in another issuance of another office action. And so we've just lost a year, right? 2 6-month periods, we've lost a year. And then many times there's still a final rejection. So we lost a year, final rejection. And so this here means an entire year was wasted, and granting the authority to set an office action response for a period that's shorter than the 6 months will definitely improve the process in terms of efficiency. I think the fix or the help to balance it out is the fact that if an applicant needs more time and say only 60 days was set or 90 days was set and they need more time, they have the ability within this rule here to ask for more time if they believe they need more time. So we believe, the careful implementation of this rule definitely will improve on efficiency as well as address concerns that are being raised here. We trust that the USPTO will carefully navigate this and create, just a step-by-step process so people don't get lost. And I'm not speaking on behalf of a large corporation. The majority of our clients are new, emerging businesses that are just now getting in this game. The other rule is the third-party submissions rule. I love this one. I personally love this one. We believe that this rule is extremely helpful and will add more of a judicial process feel at this filing level. Currently, the examiner sort of serves as judge and jury, and coming from a litigation background myself, this has always felt slightly uncomfortable. So with this new rule in place, it'll ease some of that for us litigators, as well as allow, the ubiquitous opposing party to have a say. So I love this one. And finally, I think at the bottom of the notice, it talked about the rebuttal presumption of irreparable harm. I think this is a perfect finishing touch to the Trademark Modernization Act, because in allowing a trademark owner to seek injunctive relief at any of these phases serves the efficiency process. We're all about efficiency here at Artworks because we're trying to get new businesses up and going. We're trying to work with entrepreneurs. We're trying to work with expanding businesses, and we love it when we can squeeze any kind of efficiency out of it. We deeply believe that this will allow trademark owners to more effectively police their mark. And while no rulemaking is, specifically needed to do this, simply having the USPTO come out in support of this is an amazing win for new and emerging businesses who often fail in these early days, in these early stages, and simply, need all the support they can get in this process. So those are just our comments. Those 4 really stood out to us. And so on behalf of Artworks, thank you for allowing these comments.
Thank you so much for your comments and your enthusiasm. I appreciate the support. Thank you. The next speaker we have is Nehal Manthani.
Hi, can you hear me?
Yes, I can hear you.
Great. My name is Nehal Madani. I'm the CEO of Alt Legal. First, thank you for the presentation to speak today. I, like many others, applaud many of the changes the USPTO is making to improve the integrity of the trademark registrar. There are a number of trademark service providers like ourselves that rely on underlying USPTO trademark data and related APIs to offer services to the trademark community. In the case of my company, we provide trademark docketing software and rely extensively on the TSDR API to make that possible. As the USPTO implements the changes under the TMA, we would request that the USPTO consider the technical implementation and give IP technology providers using USPTO data ample advance warning of and guidance about what's coming so that they can update their technology, continue to serve the IP community, and practitioners will not be affected adversely. Lastly, we would encourage special care to ensure consistency and predictability in setting any flexible office action deadlines, as it would have direct impact on docketing as well as other services provided by technology providers. Thank you.
Thank you very much for your comments. The next speaker we have is Angela Grayson. Angela, are you online? Oh, okay. I guess we're going to unmute you so you can speak, but I don't think we'll have video. Angela. Okay. I think we'll have the tech people continue to work on that. So let's move on to the next speaker, which is Steve Baird. Mr. Baird, are oh, I see you're coming online here. We'll wait a few minutes for connection. Bear with us. Oh, we have Mr. Baird coming online now. He's muted.
Thank you, Ms. Cotton.
Mr. Baird.
Can you hear me now?
Yes, I can hear you.
Wonderful. Well, I'm Steve Baird, a shareholder with Greenberg Traurig, but my remarks today are not on behalf of any particular client or the firm. So these are kind of my personal views as a 30-year practitioner in the trademark space. And I'd note initially, thank you for all of those speakers that preceded me. Their insights and concerns have really addressed most of the issues or questions that I've had about implementation of the TMA. So I'll limit my remarks instead of kind of piling on to any of those comments to talk about the identity of the protester. Ms. Cotton, you mentioned that there really is no standing requirement, and the statute doesn't contemplate one allowing any person to file to seek a non-use ex parte proceeding, as is the case with the now codified letter of protest procedure. One of the things that I'll note in that letter of protest procedure is that it currently shields the identity of the protester without someone seeking a FOIA request to perhaps obtain the filing that triggered a refusal during ex parte examination of a pending application. I'm wondering whether the office has thought through whether to maintain that same process and procedure. And I guess I would encourage the office to think about doing that to maximize the participation and willingness of protesters to initiate those kinds of proceedings. I'd also note that I think for the success of the program, it would be important to ensure consistent decisions. And so while the TMA speaks of examiners' decisions and then the ability of the director, unless they overturn an examiner's decision, it doesn't appear that there's really any process or procedure for determining who that examiner is. And since these will all be challenges post-registration, I'm not sure who the office is contemplating having make those decisions, but I would urge the office to think about a smaller number of examiners that are kind of specially trained to handle these procedures efficiently and all on the same page about how to render decisions on a consistent basis. Thank you very much for the opportunity to raise these issues and appreciate all the work that the office is doing in this regard.
Thank you so much for your comments, Mr. Baird. We appreciate that, and appreciate the vote of confidence and support. Moving on to the next speaker, We have Robert Pierce. Mr. Pierce, are you online? You are muted.
Hello, my name is Robert Pierce with Jacobson Holman. And I thank you for the opportunity to be able to comment on the implementation of the TMA. My focus is going to be on primarily some mechanics with the expungement / examination procedure, and then brief remarks on the flexible response period. As far as the expungement goes and the re-examination, I think it's very important that the office promulgates standards on the burden that a registrant has in responding to a petition under either procedure. And I think based on the language of the statute, that the burden should be if the registrant can produce sufficient evidence that would justify registration, that they would have met their burden. Similarly, I would ask that the registrant be given about the same amount of time period to respond as a defendant in a opposition or cancellation proceeding, especially in this case, because the registrant is going to have to be able to produce evidence of use for typically multiple goods. Likewise, or not likewise, but considering the burden for the petitioner in these proceedings, since the idea here is that that the definition of use of commerce is the same as outlined in the statute, that what constitutes reasonable examination and what constitutes a prima facie case should have flexible standards based on the relevant trade or industry to reflect the fact that use in commerce has a flexible standard. In addition, in the case of expungement, because the operative word here in the statute is never, that any reasonable investigation will address use over time. So it should outline the steps that the petitioner took to investigate use starting from registration through the current period. As far as the flexible response periods go, this area strikes me as potential pitfalls for unwary applicants and practitioners, and could increase costs. So I'd like to see this to be restricted to, or not left in discretion of the examiner, but rather that there be specific standards. And preference, I'd like to see it apply to ministerial objections, such as the need for a U.S. attorney, need for the applicant's email address, things concerning like the applicant's address or entity type, things like mark description, color claims in those areas, and it should not be applied to substantive refusals under Section 2 of the Trademark Act, including disclaimers. Thank you for your consideration, and I look forward to working with the office on this rule in the future.
Thank you so much for your comments. We really appreciate those. The next speaker we have is Christina Metropoulos.
Hi, are you able to hear me?
Yes, we can hear you.
Great. Thank you for the opportunity to speak today on behalf of the members of the American Apparel and Footwear Association. My name is Christina Metropoulos, and I am AAFA's Director of Brand Protection and Manufacturing Initiatives. For those of you not familiar with our association, we are the national trade association representing apparel, footwear, travel goods, and other sewn products companies and their suppliers. We represent more than 1,000 world-famous name brands, and AFA is the trusted public policy and political voice of the apparel and footwear industry. The apparel and footwear manufacturers and companies who are part of our membership are increasingly facing challenges presented by fraudulent and bad faith trademark filers. Many of our members are particularly concerned with the significant increase in trademark filings at the USPTO that are clearly submitted in bad faith. The Trademark Modernization Act is a good first step in addressing this challenge, but as our collective membership emphasizes, there are still significant challenges. AFA supports the Trademark Modernization Act and believes it allows new methods to address emerging threats to the U.S. trademark system and mitigate negative impacts on U.S. businesses. The law will provide legitimate third parties avenues to challenge bad faith and fraudulent applications that were previously not available. First, this law also gives the USPTO the flexibility to review an application in less than 6 months to be determined by rulemaking. Today, the USPTO must give applicants a minimum of 6 months to respond to an office action or inquiry by an examiner because of statutory limitations. Shortening the time for an applicant to respond from 6 months to 90 days or less would keep pending applications moving through the system, decreasing pendency. This timeframe was set when applicants had to physically mail in specimens for inspection and does not reflect the online filing system in use today. We believe that the time should be shortened to, at the most, 3 months that an application is pending at each stage. Second, the law provides several different avenues for a third party, typically a trademark brand holder, to object and offer evidence regarding registrations and pending applications. Today, a third party has no effective and timely path to present evidence of bad faith or challenge a pending application, or for that matter, an issued registration. This legislation codifies an informal process and makes it a requirement to include evidence filed in support of an objection within the application. An examiner is required to review challenges as part of the application process. Third, the law establishes expungement and ex parte reexamination as alternatives to challenging a bad faith or fraudulent application. Today's opposition and cancellation proceedings are too slow and too costly to provide an avenue for relief during the clearance process, often taking up to 3 years. This law allows third parties to submit evidence of bad faith and raise challenges to bad faith applications earlier on in an expedited resolution schedule. This could then become a viable means of removing an obstacle to use or registration as part of the clearance process. If applications were faster to challenge, this would be an indirect means of weakening the publicly reported incentives for filing fraudulent applications. Collectively, these avenues could become a viable means for third parties to help declutter the register. As I said, AFA supports the Trademark Modernization Act and views it as an incremental step to combat fraudulent applications. However, our members remain concerned that the expungement, ex parte reexamination, and letters of protest continue to put the burden and cost on legitimate brand holders to police the trademark registry. While we are grateful for these additional tools, we're hopeful that the USPTO will consider measures they can implement without legislation. We look to the USPTO to find ways to work with industry and to use existing authority or develop new authority to prevent these bad faith registrations that so clearly harm our trademark members. AFA would like this to be a partnership with the USPTO, which increases scrutiny and examination of applications that are coming in, especially those applications that indicate the marks are in use. In closing, the development of IP and a strong means to protect our members' designs is key to the success of our members. We appreciate the opportunity to participate in the roundtable, and we look forward to providing written comments during the rulemaking process. Thank you.
Thank you so much for your comments. For the next speaker, we have Susan Brozek-Scott.
Good afternoon, and thank you for this opportunity to speak with you today and offer some comments about the implementation of the Trademark Modernization Act. My name is Susan Brozek-Scott, and I'm the founder of a small woman-owned business, a multimedia production company based here in Pittsburgh, Pennsylvania, that launched during the 2008 recession and is somehow still standing despite rigorous challenges, particularly those posed in the past year by a global pandemic. I have to confess that until last week, I did not know that the TMA had even been passed by Congress and signed into law in late December. I do try to follow IP issues, but 2020, as we can all attest, was a year unlike any other in our lifetimes. We all face the challenges of keeping ourselves and our families safe, our children educated, our jobs and businesses afloat, and our trademark registrations live, while at the same time, we tried as a society to process all the other major issues in our country, from a presidential election to issues of equality and race. But fast forward to today, March 1st, here we are. I found out Friday would have this chance to give input today, so here are just a few thoughts I have on the TMA. First, regarding flexible response period for office actions that the law says can be shortened, I understand, from the 6-month response time down to not less than 60 days. As a small business owner, I would simply ask you to consider, as you implement this, how it will affect people like me. Many of us, especially women and minority-owned small businesses, are uniquely challenged right from the start. We often struggle for critical initial funding, and by necessity, we invest our own money and wear many hats that presidents and CEOs in middle and medium to large companies don't necessarily have to wear. We juggle projects and multitask, often alone, to enable our companies to survive until we can bring in enough revenue to hire additional staff. When we respond to office actions, even with the representation by an attorney, we have to stop what we are doing to gather the evidence or work through with counsel what we need to do or provide to comply. In our world, 6 months is doable, but compressing that response time to 2 months can create on this end a lot of havoc, especially if we have to turn our attention from a major project on a tight budget and deadline. And if we need more time to respond, if we do have to file for extensions, I understand that under the new law, there will be new fees. Now, to a large corporation, that this may be a normal cost of doing business. To those of us with far fewer financial resources, this hurts. It can hurt a lot. We all know the meter is running on legal fees too. We ask ourselves, how long is this phone call? Is it 30 minutes? Is it an hour? How long is it going to take for my attorney to write or call back? Where is the money going to come from that's not in the budget to pay for these additional calls? What if my attorney is in the middle of a trial or other case? As a small business, will I get enough of their time and attention in this new shortened span? It is a concern. In the second area, the TMA on reexamination and expungement proceedings. Let me just digress for a moment to say that a decade ago, many of us were encouraged to file in multiple classes, multiple items, and tens of thousands of dollars in filing fees later, we had to move at the speed of light on small resources to create all the products to prove use. Some real-life examples would make a great study, a book, or a documentary. But now it's my understanding that anyone can initiate either the expungement or reexamination proceeding, even if they have no legitimate interest in the registered trademark. This can create a potential for abuse and can be even more costly to legitimate trademark owners, especially those who can least afford it. Now, having said all that, I understand the need to accomplish the goals in this new law that was drafted and passed with bipartisan support as part of the omnibus coronavirus relief bill. So here is one suggestion. Rather than attacking this just on the back end, might it also be useful to put more effort on the front end? That is to extensively educate first-time trademark applicants in short, easy-to-understand videos, or even better, in an open online class about what they will need to do specifically and simply to maintain their trademarks. I did search to find this material and saw that there are now helpful long format videos on the USPTO website and now on YouTube. But some studies show that shorter 6 to 8 minute YouTube videos tend to hold our attention span better. Again, as you look at the implementation, this is simply another tool to educate small business owners. Trademark attorneys obviously know all this, but we might have better outcomes all around, less expense and less frustration if there was a way to add additional resources on the front end. I greatly appreciate your time and the opportunity to speak with you today from Pittsburgh. I've learned a lot on my own intellectual property journey, had some wonderful victories, some hard knocks, and I usually don't speak out on issues like this. However, I'm taking a cue from the late Supreme Court Justice Ruth Bader Ginsburg, who quietly suggested we should, quote, fight for the things that you care about, but do it in a way that will lead others to join you. I thank you so much, and I feel this is a very important topic.
Thank you so much for your comments and for the small business perspective. We appreciate that. I understand that the next two speakers on our list are not online, and we're still trying to connect Angela Grayson. Do we have Angela? I see Angela Grayson is trying to connect. We'll give her a minute.
Hi, this is Angela.
Angela.
Hi.
Hi, we can hear you.
Great. A little bit of drama today, but that's par for the course, right?
Right.
Thank you so much for the technical team working with me to help resolve some of my technical difficulties. And I want to thank the USPTO for holding this forum for stakeholders to discuss. I'd like to really mostly share my concern around this shortened statutory response period, or as you call it, the flexible response period. I'm also a patent practitioner, and so on the patent side, we are certainly used to what we call the shortened statutory period for response. But I'd like to echo some of the sentiments that Susan just mentioned, and also I want to agree with Allison as well with regard for possibly delaying this aspect of the Modernization Act. I primarily work with early stage companies in my practice at Precipice IP. I've had also a fairly lengthy in-house IP counsel career, but currently I spend my time working and counseling early stage companies, and I do a lot of work in the community to this effect. I'm very concerned that this shortened period of response can really wreak a lot of havoc with smaller businesses. And anything less than 3 months is certainly not doable, in my opinion. Although I understand the need to really purge the roles of bad actors and fraudulent applications that are pending, when you create an opportunity for such a quick turnaround time, I think can be very, very, very disruptive for smaller enterprises, as Susan mentioned. There's going to also be more touch points from an attorney perspective. So there's more of a more docketing events that will have to happen. These costs will potentially get passed down to the client. There'll be more touch points in terms of reaching out to the client to say, hey, are you ready? Oh, no, I'm not ready. I'd like to go for an extension. I mean, it's just more and more legal fees. Obviously, if a client is not prepared to file his response within the shortened period of time, he'll have to purchase more time, and that's more USPTO fees. I think just in the spirit of thinking about this from the small business perspective and balancing wanting to purge fraudulent applications with businesses like Susan's and businesses like the ones I support, I think this can really have a very negative impact, at least in the short run, with regard to these businesses. And I think that if the office is looking to implement these rules, much to what Allison said earlier, since there's not this mandate to do so within the 12 months, perhaps this is something that might be pushed off a little bit into the future to make way for some of these other higher priority and statutorily necessary rulemaking. But also, you know, maybe thinking about sort of the way maybe the patent side looks at fees. On the patent side, fees are assessed based on the size of the entity. So there's small, there's micro, and there's large entity fees. So that if you are going to impose a fee on an applicant, for example, an extension of time, then perhaps it could be based on the size of the entity. So that won't necessarily negate the disruption, but it will potentially negate how much, you know, money a small business will have to come out of pocket.
Thank you so much, Angela. Appreciate your comments.
Thank you.
That is the list of those who requested to speak and who are actually online. So we've reached the end of our speaker list, and we have not received any additional requests to speak through our email box today. So I think we'll move to closing remarks by Chief Judge Rogers. Jerry.
Thank you, Amy. I'm not going to really say very much at all, but I did want to kind of follow up on Eric Perot's comment about the default judgments, particularly when we have situations where the cancellation petitioner has done their due diligence and has reached the conclusion that they're very likely to get a default judgment if they file for cancellation based on non-use or abandonment at the board. And let me give you some context and a little bit of explanation about how we came up with these default judgment stats that I'm going to talk about in a second. A couple of years ago, after a roundtable discussion about all the different things that we could do to safeguard the integrity of the register, one of the things that was discussed was the possibility of creating a expedited cancellation proceeding at the board that would not require a statutory change, because while we were lucky enough to have Congress pay attention to trademarks and to pass the Trademark Modernization Act, we didn't actually expect a few years ago that anything like that would happen. So the board commenced a expedited cancellation pilot program after having a separate roundtable discussion with members of stakeholder groups who expressed their opinions about how such a proceeding might work best. So the cancellation pilot was designed to kind of figure out what the best way to expedite treatment of non-use and abandonment claims would be before the TTAB under its existing authority to hear petitions to cancel under Section 14. Now, one of the questions that came up during that discussion was, well, what are the default rates? And we didn't really know, and we can't easily mine that data from our IT systems. So one of the things that we did focus on during the 2-year pilot that ran from March 2018 to March 2020 was a labor-intensive examination of the types of claims filed in cancellation cases, which ones go by default, and focusing on the non-use or abandonment claim cases only. In other words, the cancellation cases that involved only non-use or abandonment and didn't go by way of default, then we tried to figure out what can we do to expedite handling of those cases and get them resolved as quickly as possible. However, in trying to identify those cases that would present the best vehicles for an expedited cancellation proceeding, we did find that the default rate in all cancellations is 44%. It is 49% when there is a non-use or abandonment claim, and it is 60% when there is only an abandonment claim. So going back to Eric Perot's comment, if you've done your due diligence and you've accurately assessed the situation, you have a 6 in 10 chance by filing an abandonment claim of getting a default judgment. So that can be pretty quick. Now, Eric mentioned that it might take 90 to 120 days. That's probably right. And one of the things we do want to be careful of is safeguarding registrations that have issued and not entering default judgments too quickly. We do have the default judgment process pretty well automated now, and it should be more and more automated as we go forward, given the the growing insistence of the office to get email information and correspondence information from filers and their attorneys. So we might be able to squeeze a little bit more time out of those default processing times, but we're never going to squeeze much more than squeeze down much below 90 to 120 days if we have to investigate means of possibly serving the registrant if we got an email or a snail mail returned as undeliverable. This information on the expedited cancellation pilot, I commend to everybody's review. It is up on the TTAB website. If you go to the TTAB's homepage, there is a drop-down menu, TTAB Other News, and one of the other news items in the drop-down menu is an explanation of the expedited cancellation pilot and the results from that pilot. And so you can look at that information on our website. I will highlight a couple of things. We covered about 200 cases. So again, these are the ones that didn't go by default, but only had a non-use or abandonment claim. Now, only 21 of those 205 cases actually had to go through what we have heard referred to as a long and costly process for filing a petition to cancel. So yes, certain cases, 10% in this instance, that involve non-use or abandonment claims went through a longer process, but a great many of them were resolved. 134 of the 205 cases were terminated without the need of a decision. A great many of them settled. And so I think one of the things everyone has to keep in mind as we move forward, because there are so many unanswered questions that we all have about how TMA will work in terms of the new expungement and reexamination proceedings, and what tool in a practitioner's tool bag is going to be the best tool to use in a particular circumstance. A petition to cancel at the board, not that I'm asking for a lot more trial business at the board, but it still may be something that will be a useful tool. Again, if you've done your due diligence and you think you can get the default judgment, but it also may be a useful tool in other contexts. If you have a Section 18 situation where you are not interested in deleting specific items that are listed in a registration, but perhaps you are interested in restricting channels of trade or classes of consumers or crafting a limitation onto an ID that will make way for your mark to get on the register, that might be something that you'd still want to do in a petition to cancel. Of course, you also have, as Amy mentioned earlier, the option of not limiting your petition to just non-use or abandonment claims, and you can also consider bringing other claims. Perhaps that gives you more leverage, perhaps litigation makes you subject to counterclaims. It all has to be evaluated in terms of figuring out what the best tool in your toolkit is. But I did want to bring these options to everyone's attention and point out that we do have this information about the expedited cancellation pilot on our website for anyone to take a look at. Before I go back to Amy to wrap up today's program, I want to just clarify one thing I alluded to just a few moments ago. I mentioned 21 cases out of the 205 cases in the expedited cancellation pilot being tried on the merits. What I really should have said was in 21 cases, the parties agreed to some form of ACR that would have resulted in potential trial of those cases on the merits. In fact, half of those cases settled or the plaintiffs withdrew the cases. So we didn't actually have 21 cases go through the pilot and get decided on the merits. Rather, we only had 3 cases going all the way through the pilot and require final disposition on the merits. And at the end of the pilot, there were another 9 cases that were left in suspended status. So those might yet be decided on the merits, but it's clearly a very, very small percentage of all cases that were in the pilot that were tried on the merits or may yet be tried on the merits. That's it for now. Thank you, Amy.
Thank you, Jerry. And now I'm going to turn back to Tasha, who opened our roundtable, and she's going to close us out with some announcements. Tasha?
Thank you all for attending our roundtable today. If you have additional comments on implementation of the TMA, please email them to us at tmfeedback@uspto.gov. This roundtable was recorded, and the video, along with today's slides, will be made available on our website within 2 to 3 weeks. We will email all that signed up to attend today's roundtable once the recording and slides are available. Thank you so much, and have a great rest of your day.